Qazi Faizisa, esteemed judges of Supreme Court, Mr. Mansoor Usman Awan, Learned Attorney General for Pakistan, Mr. Shehzad Shaukat, President Supreme Court Bar Association, respected members of Bar Councils, my fellow colleagues from legal fraternity, respected members of press, Assalamu alaikum. It is both a profound honor and a significant responsibility to stand before this august gathering as elected Vice Chairman of Pakistan Bar Council. Today marks the beginning of a new judicial year, a time for reflection on achievement and challenges of the past year, and a moment to set our sights on the road ahead. Pakistan Bar Council has always been committed to upholding rule of law, defending rights of people, and ensuring that justice is served without fear or favor. As we embark on this new journey, I am reminded of the weight of the responsibilities that lie upon our shoulders as custodians of legal system. Opening of judicial year is always a time for pause, reflection and recommitment to doing better. This opening is full of hope, promise and expectations of litigants for justice. It is also one in which obligation of court to effectively discharge its mandate is put to test. Therefore, we look forward to the year ahead. We find ourselves in the midst of a paradigm shift with demands for justice, test capacity of court to adequately address them. Last year was an extremely intense year for Supreme Court, both as regards judicial proceedings as well as increase in institution of cases. Both required increase in number of judges of Supreme Court to overcome problems of pendency of cases. However, last year has been one of both triumph and tribulation for judiciary. We have seen our courts render decisions on cases of immense national importance, upholding constitution and reinforcing principles of justice and equity. Our judiciary has continued to be a beacon of hope for the oppressed and marginalized, ensuring that their voices are heard and their rights are protected. However, we have also faced significant challenges. Judiciary has been at center of intense scrutiny, with its decisions being debated not just within the halls of justice, but across the nation. Exercise of Article 184(3) of Constitution has particularly drawn attention, raising questions about its scopes and implications of suo motu actions on judiciary's role as an impartial arbiter. Past year has also seen an increase in invocation of contempt of court laws, especially in politically sensitive cases, which has further fueled discussions on balance between judicial authority and freedom of expression. As we reflect on these issues, it is crucial to acknowledge tireless effort of judges and legal professionals who have worked diligently to maintain integrity of judiciary. Their commitment to upholding justice, even in the face of adversity, deserves our deepest respect and admiration. As we enter new judicial year, it is essential to confront ongoing challenges within our judiciary. Foremost among these is the issue of judicial appointments. Strength of our legal system depends on quality of our judges, yet concerns persist about transparency and merit-based nature of these appointments. We must work towards a process that ensures elevation of most qualified and impartial individuals, free from undue influence. It is imperative that mode of appointment of judges need to be changed with consensus of all stakeholders. A more rigorous merit-based selection process is essential, ensuring candidates are chosen for their legal expertise, integrity and commitment to justice. This will help build a judiciary that commands public confidence. Article 175A provides for appointment of judges of High Court and Federal Shariat Court by a commission headed by Chief Justice of Pakistan as its chairman, which shall nominate to Parliamentary Committee one person for each vacancy as the case may be. Parliamentary Committee, on receipt of nomination from Commission, may or may not confirm nominee within 14 days, failing which nomination shall be deemed to have been confirmed. With utmost respect, I am of the view that Judicial Commission in stricto sensu is not Supreme Court of Pakistan, as it does not render judicial decisions, and any decision of Parliamentary Committee disregarding decision of Commission cannot be termed as interfering with independence of judiciary. There was a harmonious relationship between Judicial Commission and Parliamentary Committee for nomination and confirmation of appointment of of judges of superior courts. However, judgment pronounced by Supreme Court in Munir Bhatti's case, reported as PLD 2011 Supreme Court 407, has stifled powers of Parliamentary Committee. Being a member of Senate of Pakistan, I have remained chairman of the Parliamentary Committee in past, and at present I am one of its members. Members of Parliamentary Committee are of the opinion that his judgment is an encroachment on the powers and is violative of principle of separation of powers as enshrined in the Constitution of Pakistan. It is imperative to have a relationship based on law and constitution between judiciary and parliament. Therefore, such judgments need to be revisited by Supreme Court. Article 209 of Constitution regarding conduct of a judge needs to be made more effective and transparent. Effective rules be framed for deciding a complaint against conduct of a judge within a certain period. We believe in independence of judiciary, which essentially means non-interference in the decision to be rendered by judges. However, efficient court administration and case management of all cases will not impede upon independence of judiciary. There must be monitoring scheme or monitoring committee to monitor working of judges of High Court as well as subordinate courts. Such committee may be comprised of retired judges of Supreme Court and High Court. In this regard, it is also important number of working hours of judges be increased. I believe this will improve disposal of cases and redress grievances of litigants. I would request Chief Justice of Pakistan to take initiative in reforming Law and Justice Commission of Pakistan. This will help in development and improvement of legal system in Pakistan and reforming laws and statutes which have become obsolete and cumbersome and need changes with changing needs of society by removing anomalies in law and adopting simple and effective procedures for administration of law to ensure substantial, inexpensive and speedy justice. In this regard, it is imperative for Commission to take measures for coordination of judiciary and executive. Application of Article 184(3) of Constitution, particularly in suo motu cases, also warrants careful consideration. While this power is vital for addressing public issues, its use must be marked by restraint, keeping in view Article 4 of Constitution. Judiciary must balance its authority, protect rule of law without undermining principles it upholds. Regarding exercise of suo motu powers under Article 184(3), clearer guidelines are necessary. These should be developed through a consultative process with all stakeholders, including judiciary and legal community. A well-defined framework will ensure this power is used judiciously, maintaining a balance between enforcing the law and protecting individual rights. Increased use of contempt of court laws, especially in politically charged cases, has raised important questions. While safeguarding dignity of judiciary is crucial, so is respecting right to freedom of expression. We must ensure that enforcement of these laws enhances public confidence in our courts without suppressing legitimate criticism. We need to reform use of contempt of court of laws to align them with free speech and democratic principles. While it is crucial to protect judicial dignity, this should not suppress legitimate criticism. A constructive dialogue within legal community can refine these laws, ensuring fair application that strengthens public trust. Supreme Court Rules 1980 needs to be amended to provide for time limit for disposal of a case after its institution. For this purpose, once leave has been granted, all parties should be required to file skeleton arguments explaining their factual and legal position, and thereafter not more than 30 minutes may be given to each party to adduce their oral arguments. Necessary time frame be fixed in rules for early disposal of petitions as well as appeals. Urgent matters may be fixed within 14 days without any discrimination. This would go a long way in redressing grievances of litigants. That these challenges require a collective resolve to reform and strengthen our judiciary. By addressing these issues directly, we can uphold principles of justice and reinforce the trust that people of Pakistan place on us. By embracing these reforms, we can ensure our judiciary upholds highest standards of justice and meets the evolving needs of society. Let us commit to these goals, keeping judiciary a pillar of strength and integrity in Pakistan. Strengthening judicial institutions plays a key role in restoration and consolidation of peace by facilitating maintenance of law and order and fostering peaceful resolution of disputes which serves to strengthen democracy in country. In Pakistan, where uncertainty prevails with each passing day, justice must remain a guiding light. And for the rule of law to thrive, we need fearless judges. We need judges who will impart justice independent of prejudice and public opinion, but only in accordance with law and constitution. We need judges who are not afraid to do the right things within the ambit and purview of law and constitution, even if it is unpopular, controversial and difficult. This is the hallmark of independent judiciary. Three main institutions of Pakistan owe to its citizens to work and play their role within the domain as set out by the Constitution of Pakistan without stepping on each other and interfering in the functions of the other. Common man must not suffer at the hands of justice system, very institution from which it seeks justice. Let Parliament make laws, judiciary interpret laws, and executive implement laws. This yardstick should be maintained for democracy to flourish and judicial system to be maintained. For democracy to flourish and judicial system to be respected, so that citizens should be able to sleep in peace that country is functioning in accordance with law and constitution. As independence of judiciary deals with the idea of ensuring that whatever is being decided regarding a case would definitely be in accordance with the rule of law, irrespective of any external internal factor. In the end, let us reaffirm our commitment to the principles of justice, fairness and rule of law. Challenges we face are significant, but they are not insurmountable. With dedication, integrity and a collective effort, we can strengthen our judiciary and ensure it continue to serve people of Pakistan with honor and distinction. On the advent of this new judicial year, I extend my best wishes to all members of judiciary, legal fraternity and our esteemed colleagues. May we work together in harmony and resolve to uphold ideals that form cornerstone of our justice system. Let this year be one of progress, reform and unwavering commitment to justice for all. Thank you.